Welcome to Assignment 1 for the Cybercrime and Cybersecurity module required as part of the assessment for the course ZEIT8017. This assignment is submitted by Richard McGregor. The topic is an examination of data breaches, particularly as they relate to the legislative obligations in Australia. So what is a data breach? It's the intentional or unintentional release of information to an untrusted party. Now, there are a number of different definitions of what a data breach is. The most common characteristics of those definitions include the following. A data breach involves the exposure of secure, private, sensitive, and confidential data. Generally speaking, information has an inherent value. If that information has a unique parameter, then it can potentially be exploited. Secondly, it may lead to the destruction, loss, alteration, unauthorized disclosure of or access to information. And this can be done accidentally or may be done in a more purposeful manner. Now, data breaches generally will have one or potentially subsequent activities within that list. Thirdly, origination comes from internal or external actors. Internally being potentially an organization may have staff members who release information, or from an external actor such as a hacker or a cyber criminal activist, or in a larger scale, state-sponsored actors. And finally, may include a number of scenarios that involve the theft or loss of digital media containing data, most commonly unencrypted information that can be transferred by means of copying or transferring information to an insecure environment, such as the internet, or transfer of data to an external competitive entity or hostile entities. So why is consumer notification of a breach important? Well, there are lots of different implications of a data breach on an individual. The most common being is that there is an impact on their physical mental well-being, i.e. stress. Particularly in terms of cybercrime, there's often a financial loss and consequential lowering of credit status. There may be reputational damage for an individual or potentially an organization. There may be detrimental impact on asset value, such as the loss of intellectual property and so forth. But the prime precursor, I guess, to a lot of those activities is the identity theft and fraud. Okay, identity theft is the most common objective for cyber criminals, and is often used to commit identity fraud, where they can either fabricate or manipulate or steal somebody's identity to gain a benefit, okay, commonly financial. In terms of consumer notification, organizations have an ethical obligation to notify a consumer that the information given to them in good faith has been exposed, and that may mean that they notify a consumer as quickly as possible that the records have been compromised, including the indication of what the information was that was exposed. They can articulate what actions an organization has taken to remediate the situation, and finally, they can inform the consumer what they can do to protect themselves against the data breach and what rights and obligations they have. So why should there be or not be mandatory notifications? Well, there are pros and cons to both sides. Essentially, in terms of pros, this ensures that there's an improved effort by organisations to make sure that an individual's data is secure. This provides improved consumer and customer confidence. It decreases and improves the reaction times of consumers in the event of a data breach. There's, from an organisation perspective and an industry perspective, there's an improved trend reporting analysis functionality. There can be potentially improved consumer protection. And finally, it'll bring Australia up into global best practice with regards to breach notifications. On the con side, it means that there's increased reporting and regulatory burden on organisations, which obviously has cost implications and so forth. There's a negative business impact in terms of compliance costs, and potentially perception of consumers about data breaches and organisations in particular. And there's some concerns about metadata retention, okay, particularly in terms of the telco environment. So essentially, the financial burden and impact of reputational risk on mandatory notification should prompt organisations to ensure that they have adequate data protection in the first instance, and on the longer term, that'll have the additional bonus of improved customer experience and confidence. Now, does Australia have any guiding principles for a breach notification? As of 22nd February, Australia has introduced legislative obligations for organisations to notify individuals of data breaches. First such legislation was in California in 2003. However, there are a number of different significant differences between this initial law and the core principles of that law and those incorporated in Australia. I've given a bit of a comparison below, particularly in terms of definitions. So for instance, an ineligible data breach in California is any breach, whereas in Australia, it only applies when personal information is likely to result in serious harm to any individual. And there are some issues with regards to where the information is actually held as well. Applicable organisations is another principle which there is a significant variance there. In California, it's any organisation that owns or licenses computerized data, whereas in Australia, the scheme only applies to government agencies and organisations governed by the Privacy Act, meaning there are some organisations that doesn't apply to, and there's also a turnover threshold as well of $3 million. Notification period in California, companies must immediately disclose data breach, whereas in Australia, it's promptly notify individuals of likely risk of serious harm. And finally, in terms of notification exceptions in California, it's only whereby in instances of criminal investigations, whereas in Australia, data breaches involving more than one entity, i.e. multiple entities, enforcement-related activities, circumstances inconsistent with security provisions or the declarations by the Australia Information Commissioner can be an exception. So there are some significant differences in terms of guiding principles. So why has it taken Australia so long to address data breaches? Well, essentially, the first legislation, as I mentioned, was enacted in California in 2002. Australia is pretty much one of the last Western economies to introduce a similar law. However, we finally have got some data legislation. And a kind of sequence of events is presented below. But essentially, there are the primary causes of delaying this very critical legislation is predominantly elections, missed deadlines by the government. There's been lengthy public consultation and delayed implementation once it was actually passed. So, however, it's taken 5-6 years to enact. We finally do have a data breach legislation. Finally, thank you very much. My references are presented below. Thank you for listening.